creation enforcement and a little AB 130 overview, and presented by Jennifer Jacobson. So thank you, Jennifer, for coming out and presenting. She's with Vidalian and Jacobson. And with that, I'll turn it over to her.
All right. Good evening, everybody. Can you hear me? Okay, now you can hear me. Good. And you're recording and we're good? Okay, perfect. My name is Jennifer Jacobson. I'm so happy to be with you guys tonight. Thank you for coming out. It's really wonderful. I get so excited when I see board members coming to these seminars because it means that you guys really care. It means that you are putting in the extra time beyond those fun board meetings that we all have to educate yourselves and to learn. And that's really, really important. So really quick, if you wouldn't mind, I just like, since we have kind of an intimate crowd tonight, if we could start over here, you could just tell me who you are, what association you're with, and how long you've been on the board. That'll kind of help me gauge what level I can gear this to. So if you wouldn't mind, sir, I'll start with you. I heard you were the first person to register for the seminar, so I'm picking on you. He's got the golden ticket. He's Willy Wonka. All right, I love it.
La Riviera, like 64 units. I've been on the board for, I don't know, 10 or 12 years, something like that. And I'm the president of our current board.
Okay, so the College Green townhouses.
Yes.
Okay, all right. Not to be confused with the College Green single-family residences, which, yeah, those go down the street. Okay, all right. How about you?
Hi, I'm Deborah Sullivan, Brigetti, board president, Villa Teresa, 100 homes in our community. Family single-story, two-story homes. Been on the board on and off about a total of 15 years.
Oh, wow.
Signed for 3 years and came back.
Okay,
And
glutton for punishment.
I was the one responsible for hiring wonderful AMC to come and manage us. It's been a great experience and a journey and learned a lot. It's been great having them managing our community. So I love the classes they put on. It's helped me and brought me a long way. I've learned so much from the classes and the experiences that I've had, so I'm glad to be here at this one.
Oh, that's lovely. What a nice plug for AMC, too. Did you hear that, Barbara? She was singing your praises. All right. And my friend over here, the soon-to-be nurse.
My name is Dorothy Mendoza, and I'm also reside at Villa Teresa Community. I was the treasurer for more than a few years, a little over 10 years as well. We kind of came on board at the same time.
Well, I brought her to the board.
Yeah.
Okay, she recruited you. That's called recruiting.
Yes, but I remained
I
on the board.
recruited her.
But I remained on the board the whole time.
Yeah.
Okay,
So I've been.
so when she took her 3-year sabbatical, you were stuck on the board. Okay, I understand.
Thank God.
That's a real friend. I'm seeing you. Bye. Out of here for 3 years. Okay.
But I've enjoyed it, and yeah, I do agree with her how this has really helped.
Oh, good.
Because I went from being treasurer to now vice president, just allowing other people who wants to do the treasury part. But it allows us to like make good decisions when we, like you said, hold our board meetings, which we have one coming up in September. So
Perfect.
it is helps us gain the knowledge to know how to navigate
Mm-hmm.
and speak to homeowners who have questions about anything that goes on in the community. So
You feel educated.
it's great. They've done this almost every year since I heard about it. I think she used to attend it by herself, and then I start coming.
Okay.
So it's either we're usually here together or one or the other.
All right. All right.
But it's
Wonderful.
been fun, and yeah, they're great.
Great to have you guys both here from your board. Okay, let's move over here to these ladies.
So I'm Rosalie, and I've been on the board of Hills Villa over on Hillsdale for about probably at least 10 years.
Okay.
And I'm on the board of Oakwood
Okay.
Owners Association on Manzanita for a couple of years.
So you're a professional board member. You're on 2 boards. Okay.
We're on both.
Okay.
You know, you learn a lot from the seminars. You know, we need some education here, so.
Okay. So you have a background in finance?
No.
No, you just like money.
I just like to say
She just likes
good.
money. All right, good. How about you?
Hi, my name's Angie.
Angie?
I am on the board of Oakwood.
Oakwood? Okay.
And, and Rosalie's very good with the money.
Good. We need somebody who's good with money.
And I love the rules.
You love the rules. Okay. Well, this is your seminar.
That's right. I want people to do what they're supposed to do.
Right, right. Isn't it funny how everybody moves into an HOA and they see how beautiful all the lawns look and how well-maintained all the houses are, and they roll out their basketball standard and they let their lawn grow up to their waist, and then they get mad at you when you send them a letter, right? We all deal with that on a daily basis. So it's like, don't live in an HOA if you don't want to abide by the rules, right?
That's right. And I've been on the board like 7 years.
Okay, 7 years. Wonderful. Okay, how about back here?
I'm Karen, and I'm here as a supporter of my favorite board member.
Okay. Wow.
And I'm Doug Newcomb. I've been on the Campus Commons Village #3 board for 24 years.
Whew. Glutton free. So you started when you were 3 years old. Okay, okay. I like to say that about practicing law. I've been practicing law for 33 years this year. And I like to tell people I started when I was 5 years old. I was a child genius. So you and I have a lot in common. Yeah, okay. How about over here?
Hi, I'm Harlene Issa, and I am currently on the board for Northridge Country Club #2. I don't remember, 2.5 years maybe on that board. I'm currently vice president, and I've served on another HOA's board, just got voted out, so I'm in transition. But I'm also an ARC chair, so I'm very active with both communities.
Jack of all trades. So you're on Northgate, Northridge. So you're at the golf course and you're at
We're not on it.
but you're the condominiums, right?
Right.
Yes, okay. All right, I've been living in Sacramento for so long, I actually know every single one of your developments so far. So,
Howard Powell, Maryland Garden, Woodland, President, too long.
and you said Powell.
Powell, Powell.
So are you related to the Powell family that did all the development in Sacramento? No, you should just say yes. Everybody will think you're really rich. Well, okay. How about you?
Lucinda Powell,
All right,
daughter,
all right.
vice president of Miramani and Woodland, and about 11 years.
All right, wonderful. Well, thank you guys for coming down from Woodland. That's a little bit of a drive. Appreciate that. All right, how about, last but not least?
It's Robert Gill with 4100 Folsom,
Okay.
and it's about 35 years.
You started when you were 2. All right. All right. Well, thank you guys for being here. Obviously, you guys all care deeply about your associations, and I'm glad to hear the accolades for AMC. We think they're pretty fantastic as well, and that's why we enjoy working on your account. So we're going to talk tonight a little bit about, this is a disclaimer, everybody memorize it. There'll be a quiz on this afterwards. My partner, Darren Bevan, loves disclaimers, right, Barbara? He loves these things. So we have to put them in everything we do. But there'll be a quiz on that later. So we're going to talk about rules and enforcing rules, the process for creating them and enforcing them. What are some of the pitfalls? We're also going to talk about AB 130. How many people here have heard of AB 130? Everybody? Okay. Well, if you haven't, it's an exciting new piece of legislation which is going to drive you bananas. So I can't wait to share it with you if you haven't heard about it already. So just so you guys know, this is not for me. This is for you. So feel free to raise your hand, interrupt me, jump up and down. I think we have another microphone up here. Come grab the microphone, come co-present with me. Whatever works for you guys to make this learning process enjoyable for you this evening. I just want to share with you, I don't mind you interrupting me. I don't mind you asking questions. If you ask me questions that are a little too specific, I might ask you to wait and talk about it afterwards, because sometimes if things get a little too fact specific, the rest of the people in the audience aren't with us, right? So they get a little bored. So we'll try to keep everybody engaged in this process. So let's talk first about, why do we make rules in our associations? Why do we think? Well, we have to sometimes clarify our governing documents. I think of our CC&Rs as kind of like our Constitution, like the United States Constitution. And then we have all the laws that interpret and enforce the Constitution, the case laws and things like that. So this is kind of our Constitution, and we need our rules to help us interpret that Constitution, because it's really hard to change the Constitution, right? We have to get at least 51% of our homeowners usually to vote in favor of amendments to our CCNRs or our bylaws. So sometimes supplementing them through rules which the board can adopt is a much easier process for you. You also can be a little bit more flexible and a little more malleable with your rules, because you don't, every time you change the CCNRs, you have to go back and rewrite the Constitution, versus rules, 28-day notice to the members, poof, we got a new rule. So that's one reason we do it. We might comply with federal, state, or local laws. The Davis-Sterling Act is a very important act. Everybody in here is familiar with that act, right? Is everybody also familiar with davissterling.com? Yes, okay. That is a fantastic website that is hosted by a law firm that is throughout the state. They have a very large presence in our state, but it is a law firm. It is not the law itself. So it is a great resource. I would call it a library. Remember libraries where we used to go and look at books and hang out, meet people? It's kind of like a digital library for you to go and read about things. But just understand it's not the end-all be-all on the law itself. Oftentimes it provides you with an opinion. And if you dig into the disclaimers on that website, they will tell you, you cannot rely upon this as a legal opinion. You need to hire us for us to be your attorney and for you to rely upon this. So when your homeowners come into your meetings with their mountains of printouts from that website to argue with you about what you did wrong, that in their interpretation of what that website says, you can remind them that that's not our legal counsel. That is a library of information, and our legal counsel has advised us this, okay? So I just want to arm you with that knowledge. But the Davis-Sterling Act itself oftentimes changes. The legislature is extremely interested in us as HOAs due to Prop 213. Prop 213, does anybody here remember Melrose, landscape and lighting districts, right? That's kind of an antiquated notion these days due to Prop 213. And that is due to the fact that that proposition says that you need 2/3 voter approval to raise assessments in any of those special assessment tax districts, which is what the Melrose and the landscape and lighting districts were. So they laid an extra layer of taxes upon your regular property taxes. And 2/3 voter approval to agree that the sky is blue today is tough, right? I mean, getting anybody to agree that the sky is blue, 2/3 voters approval, thumbs up, is really tough. And so city and counties, as a result of that, I said 213, I meant 218, excuse me. Prop 218. When you go and fact check me, you'll get the right one when you look at Prop 218. But due to Prop 218, cities and counties started saying, we want your, Mr. Developer, Mrs. Developer, we want your association to go into a HOA subdivision. And the reason being is that we can raise our assessments every year, right? 20%, our regular assessments. We can raise our special assessments up to 5% of our budgeted gross expenses without member approval. We don't need the 2/3 voter approval. So we are much more able, as a privatized form of government or governance, to address the needs of our membership and keep our communities beautiful. And so the legislature is deeply, deeply interested in us, because 89% of all new housing is built into an HOA in the state of California right now. Cities and counties are no longer maintaining subdivisions. And so we are seeing that the legislature is very interested, because the people that live in those homes vote, and they vote for them. And so the senators are, and people in Congress are very interested in knowing what makes us tick. And some of it's good. Some of the things they create for us are very good, and some things are very bad. And so you'll give me your opinion about AB 130 when we get to that. But oftentimes they're changing things to address what they've heard is going wrong in our communities. And then they'll tell us to change our rules. Perhaps the biggest example that you guys have experienced in your tenure on the board, because we have a pretty experienced group here. I'm not going to call us old, we're experienced, right? We are well loved. So this experienced group has seen SB 323. Everybody remembers when we had to affirmatively adopt election rules, remember? And then the legislature has told us from time to time to tweak those election rules. what they want us to do. They'll say things like, regardless of what your governing documents say, you must follow this. Or they'll say, unless your governing documents say something about this, this is what applies. Here's what you need to put in your rules. If you don't put this in your rules, these default rules apply. So the legislature will guide us in the legislation that they adopt, what they want us to do with our governing documents and our rules. So these are all the reasons that we might revise our rules from time to time. So if you're ever curious how the laws apply to your governing documents and how your governing documents interact with one another, this is kind of a fun little flow chart. So we start with the most important law, which is federal law. Federal law, and we say this in law school, federal law reigns supreme. It is the supreme law of the land. It is the most important law. So state law can fill in where federal law is not already applicable. It cannot conflict with federal law. So the state laws can fill in where federal law is, otherwise federal law is supreme. If there is a conflict between federal and state law, you'll hear a term come out of the courts, it's called preemption. And the courts say that the federal law wanted to be supreme in this area, so they dictated that the states could not control this issue. Probably the most important case during our lifetime, one of the most important cases, is Roe v. Wade. The federal law was reigning supreme in what states' rights were to determine whether or not they had abortion. And that has changed. That has flipped back to a states' right issue. So that's probably a way that you can remember the preemption concept, because that's a very hot political issue for us to all deal with in our lifetime. We then have our county or city laws. We as the association do not enforce the city and county laws. I have a lot of ARCs. You're the ARC person, right? You're the gal who's a Harleen, which is a cool name. You're like a Harley, but you're a Carlene. You're a Harleen. I like it. So the ARC folks get concerned because they're like, the homeowner is requesting us to approve something that violates the county law or the city law. How can we approve that? Well, we don't enforce their laws. So I grappled with this week with the homeowners association, and we had to put on our ARC forms, because this one specific city, Folsom, has some pretty specific requirements. And we put on our form, we do not enforce the city of Folsom building code requirements. You need to get their approval too. You need to go pull a permit if necessary and get their approval too. So go get that permit first. And then we'll talk about what we can approve, because we don't want to violate their restrictions and our approval. Then we have our Articles of Incorporation. The Articles of Incorporation are the most important, the CC&Rs are first, then the Articles of Incorporation. The CC&Rs are first because they are recorded in title to all the properties. Do you know why they're recorded in title? So that they flow to all the future owners. They're called equitable servitudes, and they run with the land. That concept in law school always made me laugh, thinking these documents running along the property, right? But they run with the land, meaning that somebody who buys in your community has constructive notice of all the provisions of your CC&Rs, even if they don't actually read them. So when they come in and they sit in your board meeting and they say, I didn't read the CC&Rs before I bought here, I'm not going to abide by that restriction. You know what you say? Don't care. It's recorded in the title to your property. You had constructive notice. You can use that fancy legal term, constructive notice. You had constructive notice of all these restrictions and agreed to be bound by them when you purchased titles to that property. After that, we have our Articles of Incorporation. These are what breathe the corporate life into our association, into our nonprofit mutual benefit corporation. We are not a charitable benefit corporation. We are not a public benefit corporation. We are simply a nonprofit mutual benefit. We exist for one purpose and one purpose only. That is for the mutual benefit of our membership only. And so this is filed with the Secretary of State's office. Here's a fun little fact for those of you who like to go do research on your own and you get bored sometimes. You can look up any corporation in the state of California, whether it be a regular corporation or an LLC, with the California Secretary of State's website. As long as you have the proper corporate name, you can look on the Secretary of State's website. You can see who owns that corporation, who is their registered agent for service of process, and you can look up all sorts of things about that corporation. So that's where we look when we take on a new client at my law firm. We immediately go to the Secretary of State's website to make sure that you are in good standing with the state of California. that you've paid your taxes, that you've filed your statement of officers, that you've done all the good things that you should be doing. Because if you are not in good standing, you're not licensed to do business in the state, and somebody can steal your name. We actually had that happen. I don't know if you know that story. There was a local manager, and she owned a management company. She has since retired, but there was a homeowner in her community, and the two of them locked horns like nobody's business. And she let her corporate name lapse for a moment, and he grabbed it. So she had to change the name of her company.
Wow, so they can, even if you already had it?
Yes, as if it lapses that you are no longer allowed to do business in the state. So she learned that lesson the hard way, right? And that homeowner was extraordinarily mean, but that's a story about losing your corporate name. Then we have our bylaws. To the extent our bylaws conflict with our articles and our CC&Rs, the CC&Rs control and the articles control. So these are the order in which, of the importance, descending order. And then, of course, our rules. So talking about rules today, our rules cannot conflict with our other governing documents. And we'll talk a little bit about what happens if your rules do actually conflict. So what are some of our traditional rules? We have architectural guidelines. We all know what those are. We might have common area rules about hours of operation. When is our pool open? Pet rules. A lot of associations in the past in condos, they used to have put your dog on a diet restriction, 20-pound dog restrictions. Does anybody have a 20-pound dog restriction anymore? I don't usually see those anymore, but some older sets of CC&Rs have those 20-pound dog restrictions. Your insurance company might be really interested if you've had lawsuits involving dogs in the common area where somebody was bit and the association's insurance responded to that claim. You might find that your insurance company asks you to limit certain breeds of dogs. And that becomes a difficult issue for you because the homeowners will figure out, well, if I ask for a reasonable accommodation and my dog provides some sort of accommodation for my disability, I can maybe get around that, right? So if you get one of those requests, call Rod, call me, call Darren, call John. Anybody in my firm will be happy to help you navigate that. Very difficult question to deal with for your association. If we do have to allow that homeowner to keep that dog, we're going to make that homeowner carry a separate policy of insurance that's going to respond before our policy responds. And we're going to make them have certain restrictions on where they can take that dog. And that dog can never be off leash, and all sorts of things that are going to require that owner to pay a little more attention to that dog than most people pay to their other dogs. And nuisance, smoking rules. There's a case called Burke versus Oakwood Worldwide, where an association, it was actually a multifamily apartment complex, but they had to deal with the fact that there was a child who was severely allergic to smoke, to cigarette smoke. And there were people that were smoking in the common area, and the child was having adverse effects. And that case established that at that particular landlord, the apartment complex could restrict smoking in their common areas so that they could ameliorate that problem for other residents in the community. So we can also adopt smoking rules. Typically, it's, the biggest problem is marijuana use, because I think smoking is maybe, it depends on the person. Maybe smoking is a little less objectionable for some people than marijuana use. It depends on how you respond to that. But I know during COVID, we had a couple people who were really taking it seriously to smoke marijuana in their units, and it was emanating into other units. And so we were having to address that issue. Well, we can't really tell you what to do specifically in your unit, but if it creates a smell or a noise that goes into another unit, then the association can respond to that and address it and make you keep it entirely within your unit. So I remember writing this letter to this individual and telling him, can you please ingest, I don't mind what you ingest, can you ingest it in a more responsible way that is not offensive to your neighbors? Can we suggest brownies or maybe gummies or something different? So that was a fun little conversation we got to have with that homeowner. So what makes a good rule? We're going to look at extensions of the CC&Rs and bylaws. CC&Rs control, of course, as we've already discussed, but the rules can fill in the gaps. So we might need greater details, such as we require parking permits, or what are permissible paint colors? What are the number of guests that you can have? If we have a common area facility that's highly impacted, like a pool during this time of year, We might have to limit the number of guests that people can have accompany them to the pool so that we can accommodate all of our residents, right? Because everybody wants to be in the pool when it's hot outside. So in order for a rule to be enforceable, and this is a specific provision from Davis Sterling, the act, not the website. So it's 4350 of the Civil Code. And it has to be in writing. It has to be within the authority of the board to adopt that rule. It cannot be inconsistent with our governing documents or any applicable federal, state, or local law. It has to be reasonable, and it has to be adopted, amended, or requested in good faith. So it can't be, what makes reasonable? What is a reasonable person, right? It can't be arbitrary. It cannot violate a fundamental public policy, and we cannot have a burden that outweighs the benefit for that rule. So these are kind of the bright line tests that the courts look at when they are determining whether or not a rule is reasonable. So here's the real specifics. Is there anybody here who has not gone through rulemaking before? Everybody here has, right? Okay, so this is just kind of a reminder of how we dance this dance, okay? So we start with the board deciding what they want to establish a rule on. I would suggest you consult with your legal counsel to make sure that it comports with the law and your governing documents. We're going to give member notification before we adopt that rule. And that notification is going to be 28 days prior to the meeting where you're going to consider adopting that rule. We're going to give them the text of the rule, and we're going to give them an explanation of what we're trying to accomplish. Yes?
Can email be considered general notice, or does it still have to be mail, USPS mail?
So if it's general notice, it can be in a notice intended to notify everybody at one time. So it could be a bulletin board posting, it could be a website posting, it could be a newsletter, it could be any manner in which you are intending to give general notice to all the members. Individual notice is sending somebody something by mail to their individual address that they receive individually. Now, people can opt into receiving individual notice via email. So you can give both general notice and individual notice via email as long as the owner consents to that individual notice. Does that answer your question?
Yes.
Okay, good. So then we're going to consider this rule at an open meeting after hearing member comment on the rule. So we have to listen to the homeowners, give us their feedback on how they either like or dislike this rule and what things they think we should change. After the member comment, the rule may be adopted as you've written it. Now be careful, if in result of the member comments, if you guys decide to change the rule, I don't know that you can necessarily send out the rule with the amendment. I think you need to probably go back, go do another 28-day notice, especially if it's something substantive, right? I think good business practices is to go back and do a new, fresh comment, because somebody who didn't go to that meeting to comment might come to the meeting on the amended rule and provide comment. So I think it behooves you in the long run to be more cautious when you're doing this. And then it becomes effective when you notify the members, and you need to do that within 15 days of the rule's adoption. So when is notice required? When do we have to follow the rules on making rules? I love to say that, rules on making rules. So we're required to do this when we have use of common area, if we're addressing anything to do with the use of the common area, use of a member's separate interest. Perhaps the architectural rule is the biggest example of that. Member disciplinary procedures, when we're changing those, we're going to go through rulemaking. Rules for paying delinquent assessments or resolving assessment disputes, architectural review standards, and our election procedures. So those all need to go through rulemaking. They're very bright line. Not required for common area maintenance, because that's something the association's going to do. Specific matters without general application. If we're just doing a one-off, we don't have to create a rule about it. Setting regular and special assessments, you do that as part of your budgeting process, so that goes through a different notice procedure, and you don't need to adopt rules about that. If it's required by law, if the legislature tells you you have to do it and put it in your rules, then you need to follow what the legislature says, and you don't have to go through the comment period. If it repeals law or the governing documents, or if we have what's called an emergency rule. So what is an emergency rule? This is one where no notice can be given because we have an imminent threat to public health and safety or risk of, oh boy, those documents are out of date because the Davis-Sterling Act didn't go into effect until 1985. So those predating the Davis-Sterling Act, or they predate 1980, which is when the nonprofit mutual benefit law went into effect. Those documents are really old and really hard to work with because they don't really comply with all of the current legal requirements. So in addition to all of the other things we've talked about, we have to deal with fair housing considerations. This is kind of a really big issue. This is a hot ticket item in the legislature. Yes?
Quick question.
Absolutely.
Going back to the section where you were talking about a group comes up and does not like what the board did, and so they want to make the change, and they want to reverse what was done. Who pays for legal fees for that group?
The association pays for the vote. It does not have a fee shifting provision that would allow you to shift it to the homeowner. It is part of the democratic process that we are allowed to pay for as the boards of directors. That wasn't the answer you wanted, was it? I can tell you were sadly disappointed. Yeah, the legislature will tell us when they want to do a fee shifting provision. I can tell you they oftentimes side with the homeowner. We are viewed as an endless pot of money that can run our business as a nonprofit mutual benefit corporation and somehow make our budget balance while we're constantly being asked to do all of these things by the legislature, and we're constantly raising our assessments. And I think SB 326, if anybody here had gone through that, anybody here done a special assessment recently? Okay, you guys know all about this. SB 326 required us to go inspect every single balcony in the state of California and fix anything that was found wrong. That's kind of the crux of that law. A lot of associations with extremely underfunded reserves didn't have the money to comply with that law. So they are going out for special assessments. Some of them, there's a meeting tonight. And by the way, I'm missing 3 board meetings tonight to speak here. I was at one of which I'm thankful was a special assessment meeting that I didn't really want to be at to talk about why we needed to impose a $50,000 special assessment. Wow. I'd much rather be with you guys than talking about a $50,000 special assessment.
We put in a $600 special assessment last year.
Uh-huh.
And we were told that, and it wasn't AMC, but we were told that that was, what do you call it? Emergency fund. Emergency assessment. And so then people got nervous because then the companies that were taking their loan, was wondering, well, are these falling apart or what? You know what I mean? They didn't want to give the loan on. But, it wasn't like that.
Right.
We had to leave the premises to get these things done, the balconies. But it kind of created a little problem there with people that were purchasing at the same time condo.
Yeah, what's happened with Fannie Mae and Freddie Mac, who are the federally insured loan guarantors, they have taken a very large microscope to our associations, and if they know that you haven't done your SB 326 or you're not fully funded in your reserves or you're in surplus lines of insurance, they may put you on what they call a blacklist. And they may not fund loans for people that would otherwise qualify for like VA loans. And which means your community becomes less desirable to a lot of people who might otherwise buy there because they cannot get those federally secured loans, which they worked hard for. They served our country, a lot of them.
But again, and that has to do also with the not having as many renters. It has to do also with that, right? We need to have
Correct.
25%.
Yeah, we have a law in California that we cannot require less than 25%. We can require more renters, but we can put the rental cap at 25%, which is an agreed upon number with Fannie Mae and Freddie Mac as a pretty good thing for them. So they like to see those 25% restrictions because the thought is an owner-occupied community is much more secure than a renter-occupied community. That is the thought from insurance companies and from mortgage guarantors. So that's why we see a lot of communities that have those rental restrictions are a little more favorable than others. So if you guys haven't adopted one of those restrictions, talk to your attorney about putting one of those in place. The cool thing about them is they don't apply retroactively. Everybody's grandfathered in. So anybody who owns a home at the time you adopt it is not subject to the restriction. It's only the people that buy into the community. So there will be no investors that are entitled to rent until you get to your rental cap. You can't have any speculative investors that are entitled to rent. All right? Okay, so we have our fair housing list, laundry list of stuff. We have to be careful that we don't treat people differently based upon their age, their religion, their sexual preference. We have to make sure that we don't have disparate impact on families. There is a restriction upon discriminating against familial status. So telling people that no children, we had one association, no children can play in the common areas. That is an objectionable restriction. You have to say no people can be playing in the common area. You have to make it, and if you talk about children wearing diapers in the pool, you have to talk about everybody wearing diapers in the pool. So I got a giggle out of that one. Right, so we're gonna keep it away from the ages and keep it more to the activity itself. Because
I saw skateboarding there, and I'm thinking cycling is kind of similar.
right, well, we have, some of our communities have very blind curves where we don't want people skateboarding or, God forbid, riding those little scooters that they ride now, where they come flying around the corner. And
Literally, I couldn't really she just tried to beat me out of the gate, and I was like, oh my goodness.
and they don't stop at the stop signs, and they don't care. And when they get hit by a car, guess who's gonna respond to that insurance claim? Our insurance. Because it's in our common area.
And he wasn't using a helmet either.
No, why would you wear a helmet? You're invincible when you're 8 years old. So
if you have a reason, it's okay?
right, work with your attorney. We want to make sure that your rules are not discriminatory. So we're going to keep them as uniform in their applicability to all of our residents and all of our guests so that we don't violate any of these standards, right? Talking about reasonable accommodations, how people apply for reasonable accommodations. Service and therapy pets are a big issue now. Architectural rules, of course, parking restrictions. Fair Housing Administration rules. We have an obligation now under the Fair Housing Act to affirmatively investigate claims of discrimination. So if we have two neighbors that are not getting along with one another, and it's a classic neighbor-to-neighbor dispute, you have a barking dog, I hate dogs, this is totally not true, you hate dogs, I love dogs. So let's do the true, maybe you don't hate dogs, but you have two, I have three, so I win. But and one cat. Do you have any cats? No. Okay. Well, see, I win then, because cats own us. We don't own them. So, but we have this classic dispute about dogs. You don't like dogs. I have 4 dogs, and my dogs are barking all the time. You don't like it. Then we start having this discriminatory back and forth. You tell the board I'm discriminating against you, and so forth and so on. The board has to actually do something about that. They have to do some sort of investigation. The investigation may be nothing, because there's nothing we can do as an association other than to politely ask you to get along with one another. We might call you into an IDR and do a meet and confer and see if we can navigate something for the two of you to exist next to each other. But oftentimes these things just result in, they just hate each other and they live next to each other, right? And they just have to figure out how to coexist. So we might send them, which I did to 3 people today, 2 of whom are on the board, 2 board president, board vice president. In between them is the person they collectively hate, lives here. And these 2 want us to do something to her. She's selling her house. She's like, I'm out of here. And so I just sent all 3 of them a letter saying, we're out of here. This is neighbor-to-neighbor dispute. The association's done its investigation. There's nothing we can do. Have a great life. That's the letter I said.
With your dog example?
Yeah.
There was a noise complaint.
There is a noise complaint. So then with those, when we're looking at noise complaints, we would look at whether or not it's I'll come back to you, with whether it's a public nuisance or a private nuisance. If it only disturbs Tony who's my next door neighbor and doesn't disturb anybody else in my building, that's really between me and him. But if everybody in my building complains that my dog barks all night long, every single night, and it keeps everybody in their family awake, then that's an association issue, right? It's just a matter of how many people are bothered by this and how severe is the issue. If it's a one-on-one and it's really severe, we might respond to it. It's kind of this balancing act for the association of weighing all these factors to determine whether or not we're going to get involved and intervene and try to solve the problem and use our limited resources to do so. Yeah.
Yeah, what if we have a resident that is not an owner, and it continues to bully someone else and threaten, make life uncomfortable, like if you're in the garage, to let the garage go up and down how much times, stupid things like this, and, you know, are really annoying. How can we, you know, I mean, it's gone beyond talking or anything like that.
So is there verbal altercations or is it just noise altercations?
You know, noise, verbal, and things that, in other words, things that make you uncomfortable.
Intimidation.
You know,
Intimidation.
Thank you.
Okay. Yeah, I mean, I've been adopting a lot of zero tolerance harassment policies lately. Because homeowners are people, not homeowners. People are so emboldened to be so mean to one another these days, right? Everybody thinks that they are more important than everybody else, and everybody else should be completely sensitive to everything about them, but they're allowed to be completely insensitive to everybody else. And that's just not a good way to run our world. So people who have that mentality, we've started adopting a zero tolerance policy. We have a duty as an association to provide a safe workplace for our employees, just like every other employer. And our board meetings are our workplaces. You guys are volunteers, but you're still considered personnel. You're still considered, you know, workman's comp applies. There's employment things that apply to our associations. So we are a workspace, and we do have a duty.
Talk about those decisions you're making. We want to thank all of our sponsors that are here this evening, that allow our vendors who sponsored the event this evening, that allow us to put these on. So we want to thank, Action Asphalt, Good Life, North Cal